was so nice to be with everyone. I want to thank Susan. I certainly want to thank my great partners, Victor Vital and Doug Haloftis. I have the great pleasure of working with them every day, and they win a lot. So it's great to have them here with me today. I want to give you a little bit of background about myself. First, I'll tell you that this program, we will finish on time. I'm going to take about 15 minutes to give you an overview of some things. I believe Victor's going to do the same. And then Doug's going to give a little bit more detail. Some of you do deals, some of you go to court, but all of you work at companies that have employees, and that's what Doug specializes in. For some context, I work in the middle market, primarily with private companies, and that'll give you a flavor for the types of things I look at and the trends, and it'll be relevant to what I'm talking about. So you know that I'm not talking about mega deals, which are defined as $5 billion in transaction or higher, which have actually gone up in volume throughout the pandemic. My deals tend to be companies that are privately held, $5 to $25 million of EBITDA, transaction values of about 75 million to 300 million. And I've been doing that for 19 years. So if you'll indulge me for a minute to kind of think about where we were a year ago, what's transpired, and where we are now, all as it relates to M&A. So I closed 2 transactions in March of 2020. My career was at an all-time peak in 20 years. And being an M&A lawyer in Texas was a really great was fantastic. Lots of deal volume, lots of new players. In the middle market, deals absolutely stopped for 5 months. From about May to November, there were virtually no transactions. And buyers were more focused on either getting out of a deal or trying to deal if they had a portfolio of companies that they were already having to manage, to try to keep those afloat, to deal with the reality. It was virtually impossible to value a company during this time. As you can imagine, when you're a buyer, it's very difficult to know the value of a company whose customers may all go bankrupt within the next few weeks. So there were deals that were, well underway, and those closed. I had 1 or 2, but a lot of things just went on pause, and M&A practitioners had to really think about how to best advise their clients in this situation, these circumstances. So one of the things that happened during this 5-month pause, and again, you'll find studies that show the largest deals kept going. They were opportunistic. They were able to use their stock as a currency and not rely on banks and the ready availability of capital. But the middle market really did pause. And what we saw was a big effort by private equity to form distressed opportunity funds. And so my partners that focus more on fund formation, on private equity compliance, fund compliance, and capital raising, they were quite busy. I'm more of a pure M&A lawyer, so I had to sort of take that gut check and wait for things to come around. But the government didn't make it too much easier on me, because they started pouring capital, trillions of dollars of capital into the market. And so a lot of companies, fortunately for everyone in their jobs and for, mankind and surviving this pandemic, that money was used well and served a great purpose. But it also sort of propped up a lot of companies that would have otherwise been M&A targets, because really no one in the middle market was wanting to overpay. They were really looking at this as more of an opportunistic thing, and trillions of dollars of government money sort of made that even more difficult to figure out. The good news is, though, that things are starting to come back to normal, if you will. And this is a good time to have this discussion, because even if it's informal and more individuals than large companies, people are starting to emerge. They're starting to meet. They're starting to network in person. And so I think the timing is great. And behind the curtain, there's a lot of talk about deals. There was 4 or 5 months where deals weren't happening. Banks were more focused on PPP loans than they were sponsor acquisition financing. But that gave private equity and strategic buyers a lot of opportunity to just kind of sit back, look at opportunities, get most recent financials, and really figure out where valuations are and how multiples on valuations were impacted. Going to my slides, and these are themes. So I want to say real loud and clear that I would love to meet with you or have a Zoom with you or a phone call with any of you. There's just not sufficient time to get into really drafting, and that and negotiation are my passions. But I wanted to hit some themes and give the other speakers an opportunity to talk. But if any of this you really want to get in the weeds, by all means, please, you've got my contact information. We'll do that on our nickel, and I'd love to talk to you. So for themes, valuations, what's something worth? What is a multiple on that? So typically, sellers will be paid a multiple of their earnings or revenue, depending on the industry. And I'll tell you, these trends are also very industry and company specific. I think that's the nature of a pandemic is, yes, there are some comparables, but you really have to look at the most recent financials. You really have to look at how concentrated they are in certain customers and what the financial viability of those customers is on a go-forward basis. So look for, valuation trends, multiples, deferred purchase price payments. A lot of that is deals that were inked, and there was a real question of whether these deals would go forward at all. And if they were going to go forward, people got creative. They wanted to pay full value, but they wanted demonstration that these companies could perform in a pandemic environment. And so I know 2 recent studies have come out that I found were very good. One was from PwC and another was from Houlihan Lokey. So if you want to get those from me or Google them, I think that, the first quarter of this year is key, and those studies are starting to come out. One of the most important things that happened, during last year and is really showing up in the drafting of M&A documents now is the definition of material adverse changes, a material adverse event. A material adverse event is typically something that a buyer can use to get out of a deal if they feel like the earnings potential of that company has been severely disrupted by an event. But interestingly enough, a health crisis, a pandemic, those have typically not been a carve out for a seller. So the way this functions is there's certain events that just really disrupt the economics of the business. In certain limited circumstances, buyers can walk a deal in that case, subject to these carve outs. And typically a pandemic has not been one of those carve outs. So look for that in M&A deals going forward. Also, reps and warranties of buyers and sellers. These are far more robust. You should also expect a lot more due diligence and COVID-focused due diligence. Buyers want to know whether this target company can function in a pandemic, post-pandemic environment. Look, we're doing this remotely. Companies are operating remotely. Some can do that seamlessly. Others struggle with it. And if they're not front and center, in front of mind with their customers, it's going to suffer and someone else will. Again, that's something I'm happy to go into detail with you on an individual basis, but certainly there's more focus on both buyer and seller representations. There's also a ton of focus on pre and post closing covenants. So often there will be a signing of a deal and what they call a delayed closing. So that interim period between the signing and the closing is absolutely critical for a buyer to make sure that a company is performing in the ordinary course. And as perverse as that sounds, ordinary course is really being redefined, because what was ordinary course, before we went remote, before, triple P money was being sent out to trillions of people that typically didn't borrow money, before you had to worry about whether your customers were going to be around or not. These types of this language and agreements is being much more closely thought of, and in some cases what's really there is boilerplate, and it's really much more customized now. Deal timing and regulatory approvals, I can't emphasize enough that deals are taking longer, and you should expect it. There's uncertainty, there's delays, there's shutdowns, there's rollouts of vaccination, there's new regulation. I can tell you, if you're dealing with governmental agencies like HUD or the SBA, the SBA is many months behind. So if you're trying to close a deal in 60, 90 days and it's taking 180 days for the SBA to approve a deal, you really need to think about that and how it how it impacts all the timelines, termination dates, all this kind of stuff. Real quick, CARES Act, lots of companies took CARES Act money. The basic theme is that if you keep people employed and you do certain things to operate, that money can be forgivable. In the M&A context, there's a lot of rules around M&A, though, in the CARES Act and the forgivability of that, of those program dollars. And even things that are as simple as reincorporating from California to Delaware, from New York to Delaware, which a lot of people are doing. You have to really be thoughtful about how you do that and how it impacts your loan, and how to, these are, again, things that we work on every day and that we could help you with, but I just want you to be aware of it. Finally, reps and warranties insurance. If you are in the business of M&A in any way, that the proliferation of reps and warranties insurance has been astronomical. If you go back 7 years ago, there was virtually no reps and warranties insurance. I think it's in 85+% of the deals now. And this impacts things like the amount of money that would go into escrow and be subject to indemnification. It gets a lot of deals that are otherwise harder to close because a buyer can look to an insurance policy. But insurance policies are written by insurance companies, and you can bet they're very focused on COVID and exclusions and how the reps and warranties function and work. And you really need to make sure you have a good consultant for that, and that, what you're expecting is what you get. So, and I really appreciate your time, and we really respect and value our relationship with ACC.
Good afternoon, and thank you for having me. I'm delighted to have this opportunity to talk about employment law issues as it relates to COVID, as the pandemic hopefully is winding down. There are three areas that I wanted to talk about concerning COVID impact as people begin to think about returning to the office and the workplace and the like. And the first is vaccination policies. And then I thought I would spend a few minutes looking at the new legislation and how that impacted COVID benefits that have been extended on a voluntary basis. And for those of you that have been worrying or having sleepless nights, wondering what's going on in the COVID litigation tracking world, who's getting sued for what, I thought I would spend a few minutes speaking about what we're seeing in our own COVID litigation tracking and what's widely available through other tracking systems that you can find on the web. So first, let's talk about vaccination policies. I've been getting a lot of calls. 14% of the country as of today has been vaccinated, 46 million people, 130 million doses of the vaccine administered, 81 million, or 1 out of 3 people, have been received at least 1 dose of the vaccine. So you can start to look at various surveys of chambers of commerce in large cities throughout the country and get a sense of where employers are and what their current thinking is about returning to the workplace. And if you look at some of these, most currently still have office employees working on a voluntary status with hard caps for returning to the office and contract tracing procedures in place. They're encouraging but not mandating vaccines. They're still discouraging travel, except essential travel. And they're not considering fully reopening until the fall of 2021. Now, in this algebraic equation I'm laying out, the percentage of people that have been vaccinated, what businesses are currently thinking about, the other component is the CDC guidance. And the activities that are permitted for fully vaccinated people is they can visit with other fully vaccinated people indoors without mask and without physical distancing. They can visit with the unvaccinated people in a single household who are at low risk without a mask or social distancing. And they can refrain from quarantine and testing following a known exposure to a COVID-infected individual as long as they are asymptomatic. And when in public, they have to continue to generally follow the recommendations of pre-vaccine vaccination CDC guidance, mask coverings, physical distancing, avoiding large and medium-sized group. So with that formula, the percentage of folks vaccinated, what employers are thinking about in terms of reopening their office, and what kind of the CDC guidance on vaccinated people and the activities they can be involved in, what kind of vaccination policy, if any, are employers currently considering? Now, it really is, the law professor in me always says this is sort of a remarkable discussion to be having, because when I began practicing employment law more than 30 years ago, the ADA had just been enacted, and that was a sea change. And the sea change was you couldn't discuss medical issues in the workplace. You couldn't ask employees about their medical condition. You couldn't make pre or post-employment medical inquiries except on very limited basis. And then the pandemic comes along, and these laws, at least with respect to COVID-related issues and conditions, are turned on their head. And so the current EEOC guidance is it does not prohibit a vaccination policy, a policy that strongly recommends or even mandates vaccinations for the workforce. Now, you have to be careful. There are a few states that have introduced bills that would purport to prevent compulsory vaccination. Now, these have not been enacted. They're just bills that have been introduced in New York, which would prohibit compulsory vaccination in the workplace. And there's been bills in South Carolina, Washington, and Minnesota where you could not take an adverse employment action against an employee because of his or her refusal to be vaccinated. So if you're a multi-state employer and you're considering these policies, you'll have to keep an eye on this legislation as it evolves. Now, if you're considering a vaccination policy, there's some legal risk considerations that I hear. Oh, what if there's an adverse reaction to the vaccine and we've mandated? Is there legal liability there? And generally, that sort of claim, and I don't mean to be dismissive of it, in the rare event it occurred, would be covered by a subscriber's workers' compensation insurance policy, and any sort of tort claim would be preempted. And then on the flip side, I hear, oh, is there legal risk to the company if we don't have a mandatory policy? And I don't think failing to mandate vaccinations would increase your liability with respect to premises liability or workplace safety rules under OSHA, as long as the company is continuing to follow CDC and OSHA guidance concerning safe practices. And as we'll see, if I get to the litigation, COVID litigation impacts, you'll see that wrongful death, personal injury relating to exposure is really one of the smallest areas of claim filing that we've seen since the pandemic. And so again, if you're thinking about this vaccination policy, there will be some civil rights issues under the ADA. If an employee objects to the policy because of a medical condition, you'll have to engage in the mandatory interactive process to see if some accommodation can be reached regarding the vaccination policy. If an employee raises a Title VII religious-based objection to the vaccination based on some sincerely held religious belief, again, we'll have to engage in the interactive process to see if that's something that can or cannot be accommodated. You'll also have to be careful while post-COVID regulation has opened the door to these medical inquiries. We still have to be careful in the kinds of questions we ask, what doors we open that might relate to other underlying medical conditions. And so the types of documentation that you request in connection with proving whether someone has been vaccinated or not, I would be careful about that, and we'll have to take proper precautions. So with respect to the vaccination policy, my current recommendation, my advice is don't mandate it just yet. Vaccine is not fully available in all venues and jurisdictions. If you're inclined, you certainly can strongly recommend that employees be vaccinated. You can, with impunity, provide non-coercive incentives to get people to get vaccinated, gift cards, just like you would with any wellness program incentive, additional PTO, nominal cash bonus. And then I think you've got to get the HR team involved to make sure they can handle any objections. They're equipped to have a discussion about why there's an objection. People have to be trained on what questions they can and cannot ask. You can certainly ask, have you been vaccinated? Yes or no. But if the answer is no, you probably can't ask why not, because that might open the door to these impermissible legal inquiries and medical information filtering into the workplace. You could ask, do you object to being vaccinated? You could say the company has a policy which requires you to be vaccinated. Will you comply? Yes or no? If no, can you provide a medical certification from a licensed physician saying that you cannot be vaccinated? We don't need to know the underlying reasons. And if you object on religious reasons, well then, yes, you can open the door there and ask why. And we can see if there's some accommodation that we can or cannot acquire. Because we have a mandatory policy, we can't pick and choose who it's going to apply to. It's going to, if it's non-discriminatory, it's going to have to apply across the board. So I hope that covers it there. I've had a lot of discussion with folks on this issue. They are very interested in how to deal with the vaccination issue, and it creates a spirited discussion when we look at the pros and cons. Two primers here on the Families First Coronavirus Relief Act. The benefits that we saw enacted in March of 2020, paid leave, because of a quarantine order, school shutdown, COVID-related illness, to care for someone with COVID. Those benefits all expired formally on December 31st of 2020. Now, even under the old law, an employer could continue to provide the paid benefits, again, subject to the caps, subject to the limitations, through March 31st of 2020. Voluntarily, you could provide the paid COVID-related emergency sick leave or family leave at your discretion. And then, if you paid for the benefits, you could offset the expense of the benefits against your payroll taxes, your payroll tax liability. Now, the American Rescue Plan Act, signed on March 11, extended the voluntary continuation of those benefits through September 30th of 2021. So again, if you want to provide the benefits through September of 2021, full pay for up to 80 hours for a government quarantine advised by a healthcare provider that the employee should self-quarantine experiencing symptoms. And also the basis for the leave was expanded if someone's waiting for test results, experiencing symptoms and seeking a medical diagnosis related to COVID, is exposed to COVID, or has been requested to seek a test or a diagnosis. Those are additional grounds in which you can provide the paid leave up to 80 hours. It's capped at $511 per day, $5,100 aggregate. You can do that voluntarily up through September. It resets as of April 1 of 2021, so you don't count the leave that's been previously provided. Resets as of April 1. If you want to provide it, you may, you're not required. The same with caring for a child because of a school shutdown, or a required caregiver for someone with COVID. There's 2 weeks. It's basically been expanded to 14 weeks of paid leave. That caps out, it's 2/3 of compensation, not to exceed $200 per day or $2,000 in the aggregate. Again, these are all completely voluntary requirements now, but these are benefits that if you want to provide your employees, you certainly can and probably should, and the government will underwrite it. I've just got about a minute left, so I'd like to just talk for a few minutes or a minute about the COVID tracking, because it's always an eye-opener to me when we look at these numbers of case filings, what kind of cases we're seeing. And, when it started, the pandemic started, there was a major concern about liability, premises liability, exposure in the workplace. And I can really tell you, looking at these case numbers, that is really one of the lowest areas of concern in terms of tort litigation. It just hasn't materialized. There has been approximately 10,000 cases filed since the pandemic that are COVID related. About 10% of those relate to civil rights issues. Those are cases where someone is complaining about a government shutdown, a business closure, stay-at-home order, or they're a private party trying to enforce a government ban of some kind. About 5% of the cases have involved educational institutions where people have been seeking refunds because of COVID-related shutdowns or virtual learning. So the largest areas of claims, not surprisingly, has been in the labor and employment area. About 20% of the cases have been in that area, but only about 1% actually deal with exposure to COVID. So unless you're a meat processing plant or a hospital or a cruise line or a nursing home, you don't really have to worry, at least from a litigation standpoint, from these case filings, about a claim concerning exposure to COVID. The causation issues just seem to be too difficult. These 2,000 plus cases, the 150 cases a month that we see in the labor and employment area, they basically concern accommodation and disability and discrimination based on the application, the administration of COVID benefits. And then finally, the second largest area is insurance related for COVID claims, about 20% having to do with business interruption. And so finally, only about 3% of the claims have dealt with wrongful death or personal injury due to COVID exposure. My time is up. It's been great to have you. I'm glad I can plug Victor back in for the final 15 or 20 minutes. And again, if there's any questions, you know how to reach me, follow up. I'd be happy to talk to you about any of these issues further.
I'm going to now advance the slide and tell you, I'm quite proud of these slides. Never before have I done a PowerPoint presentation where my bullet points were trapezoids. So you gotta love that. Essentially what I did is I had, for instance, the first trapezoid is my first bullet point. The remote litigation is the second bullet point, with the sub bullet points to that one being what you see there. And we have a fantastic marketing staff in the Dallas office, and they turned my simple PowerPoint into trapezoids and bullet points within trapezoids. So I'm pretty enthused about that, as you can see. I'm also enthused by this new normal that we're in. Never before would I have thought that I would be presenting to the Dallas Metroplex and people from all over the Metroplex from the comfort of my own home with headphones to boot. As professional gear, I show up to phone calls with clients, with judges, etc., and I have on my headphones, and people very rarely make any comments about them because they either have on headphones or earbuds. So I like these headphones because they're noise canceling. Hopefully we can keep noise to a minimum. With that bit of frivolity, let me move to some substance. So focusing on the first trapezoid instead of the first bullet point, focusing on the first trapezoid over this past year, what we saw with COVID-19 was that COVID-19 wrought havoc on commercial and contract dealings. Many of you experienced business disruptions from complete and partial shutdown of operations to the complete, to the complete and partial shutdown of delivery of goods and services. Experienced delays, modifications, and cancellations of bookings, orders, and events, and failure to meet capital calls for those who are in the world of business or investment partnerships or real estate partnerships. And those are just a few examples. Those events caused us all to scramble. And the key question that we asked ourselves early in the pandemic, and there have been many articles and many presentations written and given about this question: who should bear the risk of economic loss from an unforeseen and undesirable contagion? How should losses be accounted for and allocated between commercial counterparties related to this pandemic? And how should businesses determine their rights, recourse, and obligations?
Emerging from this pandemic, parties will be keyed in like never before to contract boilerplate that often went unnoticed before the pandemic. As a commercial litigator, it's all about the contract. This pandemic, however, has taught us that we should be focused on things that we didn't focus on before, to include so-called boilerplate that often gets goes unnoticed or gets included in contracts as an afterthought. Boilerplate provisions are generally considered miscellaneous and they're usually situated at the end of contracts like they were afterthoughts. But emerging from this pandemic, we've learned that these typically glossed over items can be and are critical in spelling out and defining rights and obligations in the event of unforeseen potentialities. So-called boilerplate, therefore, is very critical in going forward. Emerging from this pandemic, contract counterparties should give a whole lot of thought, or much more thought, to such boilerplate than they did in the past. Of course, the boilerplate that was the commercial phrase du jour of this pandemic was force majeure. We saw a lot of litigation during the pandemic regarding force majeure. I personally saw, and I'm sure you all experienced, and hopefully you don't fall into the bucket where this applied to you, but there were some poorly drafted force majeure provisions. Emerging from this pandemic, I encourage you all, if you've not done so, to visit with a corporate lawyer like John to make sure that your contracts have robust and very effective, specifically defined force majeure provisions. Also, we saw litigation regarding indemnification provisions, who should bear the risk of loss to third parties arising from this unforeseen potentiality that we actually are experiencing. going forward, you'll want to make sure you have clearly defined indemnification rights that clearly outline who or which party, if any, should be the insurer, so to speak, vis-a-vis third parties in the event of undesirable eventualities. And finally, I've seen clients personally who are well served by limitation of liability provisions and well-drafted liquidated damage provisions. Going forward, well-drafted limitations and liquidated damage provisions are critical in providing certainty and reducing the protraction and cost of litigation when you're in the type of calamitous situation, or unforeseen situation that we're now experiencing and emerging from. And beyond the contract, we saw that implied conditions supplied by common law could be used and as a tool in our toolbox as commercial litigators that we should be aware of. We've seen clients without force majeure provisions who have argued that an implied condition of their performance was that an unexpected contingency like COVID-19 creates a situation where performance is impracticable or impossible. And occurrence of that unexpected contingency was unexpected, and performance was therefore impossible. And finally, there's some UCC provisions that we have litigated that should be in the forefront of your mind to the extent the UCC applies to your business. UCC section 2.309, for instance, talks about delivery within a reasonable time period. Obviously, what's reasonable depends on the circumstances. Also, interestingly, and this is a creative argument, UCC section 2-609 applies to situations like we're in right now. It allows a party to demand adequate assurances of future performance from an opposing party if they have a reasonable basis for insecurity. Now, as a matter of strategy, a party that is unable to perform before declaring, hey, because of COVID, I'm unable to perform, or because of some unforeseen contingency, which will surely happen in the future, rather than confessing that up front as a chess move, you might consider seeking adequate assurances from your contract counterparty if you have reason for insecurity regarding their performance. And if they can't provide you adequate assurances, that gives you rights under the UCC. And finally, UCC section 2.615 talks about, it is a force majeure type provision that talks about contract performance being made impracticable because of the occurrence of a contingency based upon that could not be foreseen, or based upon compliance with good faith, in good faith with government regulations or orders such as quarantine or stay-at-home orders. Now, next, moving to the next trapezoid, I wrote an article early in the pandemic, around April of last year in the Texas Law Book, called "Remote Hearings, Let's Hope They Become the Rule Rather Than the Exception." I wrote that piece a few weeks into the pandemic and stated my view that it makes no sense that in-person hearings are considered the rule rather than an exception. Since the publication of that article last year, we have seen that despite the misfortune of the pandemic, we faced and met the unique opportunity to bring litigation, as I was preaching in that article, into the technological age with remote litigation solutions. This pandemic has taught us what activities are truly essential, and I believe emerging from this pandemic, we'll see that in-person court appearances and hearings, and in some instances, some trials that are not exhibit heavy or complex, can and will be conducted virtually. This actually has the benefit for corporate clients because litigation that is remote is much cheaper and more cost effective than requiring lawyers to jump on airplanes or sit in courthouses than it is to launch from your office or your home office like I'm in right now. Moving to the next trapezoid, while the jury apparatus is now kicking back into gear with vaccines moving apace and the COVID numbers going down, civil jury trials here in Dallas are expected to start back up this summer, as early as this summer. During the pandemic, however, we saw a number of parties waiving jury trials and or opting for arbitration to get their cases to decision or resolution. Coming out of this pandemic, it's my expectation that this trend will continue. In that regard, our firm had an interesting thought piece during the pandemic to help parties that were trying to decide whether to waive a jury trial to get their case to resolution. Our jury consulting division, Theme Vision, found that judges and juries actually agree with each other regarding the facts of the case and decisions 75% of the time, with an even split in the remaining 25% as to whether it was the judge or the jury that favored plaintiffs. They further found that judges agree with each other 70% of the time. Theme Vision did find, however, that jury awards tend to be more variable than judge-made damage awards, with the risks being to both plaintiffs and defendants. In other words, they found that juries awards you get lower lows and higher highs. With judges, you don't get the variability. That's a consideration for whether you want to opt for a jury trial versus a bench trial. But again, my expectation is that parties are going to increasingly move away from the jury system for judicial resolution or arbitrable resolutions. I'm not commenting whether that's a good thing or bad thing. I'm just giving you what my expectation and what my prediction is based upon what we've seen as we emerge from this pandemic. And finally, moving to the last trapezoid of my slide, I want to talk about whether social attitudes and jury demographics are changing or have changed as a result of this pandemic. Theme Vision, our jury consulting division, did some research to shed light on whether attitudes have changed and whether we should expect in commercial litigation to see a change in the makeup of future jury pools. Living through a turbulent time like 2020, where we had a pandemic and many other societal issues, has no doubt affected everyone, and many people see the world differently, or that's at least what Theme Vision theorized, and their research bore that out. For instance, pertinent to commercial litigation, attitudes have shifted markedly to the underdog to include more sympathy now for small business owners, and on the other hand, less sympathy for large businesses. Obviously, that change in societal attitudes can and most likely will creep into jury decision-making. So if you're a small business owner and or a large business owner with a commercial case and you're considering whether to go to trial, you'll want to have that as a key consideration. And obviously you'll want to test your case to see if those societal, the changes in society's views in respect to small businesses and large businesses is going to have an impact on the decision in your case. In terms of who will be in the jury pools, Theme Vision's research shows that in the future, emerging from this pandemic, we can expect to see more males. We can expect to see more affluent persons in jury pools, and we should expect to see more highly educated people in our jury pools in commercial cases. Interestingly, however, Theme Vision found that jury pools also are going to likely include people who have a very, I don't want to say an activist view of the court system, but are true believers in the need for justice from the court system. For instance, persons who will likely show up in juries now more than they did before, people that believe the court system provides a way to fix problems in our country, people who believe that the courts in our country should protect the have-nots. Again, that goes to the theme of favoring jury attitudes, moving to the underdog, such as small businesses, and juries and jurors who believe that civil juries should send a message to society through their decisions.